All right, so this will be the last lecture with any substantive content as far as units go. So we're going to finish up employment law today. You'll have a quiz on employment law due Monday night. Your discussion questions are due tomorrow. I'd like to have them all, like you to have them all done by tomorrow. We will review Tuesday for the final exam. I think it will be important for you to be here. I'm still taking attendance, and I'm going to give you the questions that are on the exam and tell you kind of what I'm looking for in terms of answers. So I think it will be time very well spent for you to come on Tuesday. Your exam, remember, is take home. It can be done at any time over an 8 or 9 day period. I haven't nailed that down exactly, but you'll have plenty of time to choose. It is cumulative in the sense that it does cover the whole semester, but it is not going to be multiple choice or true false. None of the same questions you've had. It'll be reflective, short answer. The whole thing will be short answer and reflective. So again, I'll tell you next Tuesday more about it. Next Thursday, I will be in my office for office hours for anybody that has any questions, problems, complaints, anything, issues, anything like that. Feel free to come by and see me. You can make an appointment if you want, but you don't have to. I'll just spend the morning up there. It's room 423. It's the very end of the hall on the 4th floor. Anybody have any questions on any of that? All right, so everybody knows where we are. So I'm going to finish up today talking a little bit about the Americans with Disabilities Act. What is a disability? What kind of accommodations are required? Kind of how that law applies. And then we're going to look at 2 cases that show you how the courts have dealt with some of the employment laws that we've studied this unit. One, Clark versus Champion, involves the Americans with Disabilities Act, which I'm about to explain to you. And the second case, Bostock versus Clayton County, involves interpretation of Title VII of the Civil Rights Act of 1964. And I think you'll find those to be interesting as we go through them. All right, discrimination based on disability. So the ADA, the Americans with Disabilities Act, that is a 1990 federal law, and it was brought to eliminate discrimination in hiring and firing on the basis of disability and to otherwise prevent qualified disabled workers or to prevent employment practices that would prevent qualified disabled employees from participating in the workforce. It would promote that. In order to qualify under the ADA, an employee's got to show, one, that they have a disability, that they are otherwise qualified for the job, they can still do the job, and that he or she was excluded by the employer based on their disability. All right, so this is where we go all lawyer on you. What is a disability? All right, well, the law is going to define what a disability is. If you skip down to the bottom of the page on this part of the lecture outline, proving that you have a disability involves showing a physical or mental impairment that substantially limits one or more major life activities, or a record of having such an impairment. Maybe you don't have that disability now, but you have in the past. You're still qualified. Or being regarded as having such a disability. Maybe I don't have a disability, but the hiring manager that I'm interviewing with thinks that I do. Maybe I do have a disability, but they're making assumptions about what I can and can't do based on stereotypes or generalities about people with my condition. All that qualifies as having a disability. Now, again, remember, I hope if you've learned anything this semester, I hope you've learned that there's so much room for interpretation of statutes, right? Legislative bodies, Congress at the federal level, state legislatures at the state level, they write the law, But there's no way that they can write these laws in such a way that covers everything. It doesn't define all the definitions are open to interpretation. That's the job of the courts to do. So if you just look for a second at what is a disability, and I read you this sentence: a physical or mental impairment that substantially limits one or more major life activities. I put on my lawyer hat, I'm looking at that, I'm thinking, well, what exactly is a physical or mental impairment, right? The law doesn't give you a list. This is an impairment, this is not. It just says physical or mental impairment that substantially limits a major life activity. What does it mean to substantially limit? Does that mean that I can do it, but it's really hard? Does that mean I can't do it at all? Substantially limit is another part of the definition that the courts would be interpreting or applying to the facts of a case. What about a major life activity? What is a major life activity? The ADA doesn't give us a list of these are major life activities and these aren't. It's up to the courts to decide whether or not the condition that the plaintiff is presenting or claims to have would substantially limit a major life activity. So these are all areas for interpretation in the courts. If a person does qualify as having a disability under those definitions, then it becomes illegal for the employer to take any adverse employment actions, not hiring, firing, not promoting. It becomes illegal for them to make any of those employment decisions based on the disability. Employers are also required, just as importantly under the ADA, to provide reasonable accommodations to employees with disabilities. So the ADA does not, it covers obviously situations where I didn't get hired because I have a disability. I got fired because I have a disability. It also covers situations where I have the job, but I need an accommodation to help me do it. All right, and this is where I want you to pay attention because this part to me always gets confusing. The employee still has to be able to do the job without the accommodation. Okay, the accommodation cannot be the only way that they can do the job. So for example, if my disability is that I am legally blind and I want to get a job as an air traffic controller, okay, there's no accommodation that's possible that would allow me to do that job. I guess there is. An accommodation would be I need a person with perfect sight to be my eyes. So you still have to be qualified for the job. If you are and your accommodation is reasonable, the employer is bound to do it. For example, let's say that I have a circulatory problem in my legs and I can't stand for, it's bad for me to stand for more than 30 minutes at a time. I can do it. I can still teach. Doesn't keep me from teaching. But the accommodation would allow me to do it and not and in a way that doesn't affect my disability. The accommodation I might ask for is a stool to put in front of the podium, or to be able to teach sitting down. Maybe I want a classroom that's more easier set up than that. Those type of accommodations are reasonable, necessary, and they're required by the employer. All right, what happens, Caleb, if CSU and I disagree about whether or not my accommodation request is reasonable or not? Who's going to decide that for us? The court will, that's right. Right? You saw in the Clark versus Champion case, Mr. Clark had a lot of things that he was asking for as accommodations, and Champion granted some of them and didn't grant some of them. They ended up firing him And he sued, saying that he was owed some accommodations that they were unwilling to give him. So there is a little bit of a carve out for employers in this, in that the employer does not have to make an accommodation, even if it's reasonable, if it would create an undue hardship. I think my example of that might be the air traffic controller situation. That would be an undue hardship on an employer to have to hire two people to do one job. Okay, maybe I'm a smaller business and the accommodation that the employee requests from me would require me to spend $1 million to make it happen. That would be an undue hardship on my small business. All right, so there's some leeway in there. But again, if we have a disagreement about that, whether it was reasonable or not, we're going to end up in court, and the judge or the jury is going to end up being the ones to decide. Now, think about case law for a second. Anybody who goes to court on an ADA case, and we're arguing about things like, is this a major life activity? Is it substantially limited? Is the accommodation reasonable? Would the burden be an undue hardship? There are other cases, prior cases, that courts have decided and interpreted the ADA that will help either side. All right, if I go to court on my air traffic controller case, I'm going to be looking for all the written opinions of courts who have considered cases before involving people who are legally blind. That would help me. The defendant, employer, is going to be looking for all the cases that have been argued before and decided before that involve people who are legally blind that help them. So it's not like it's a total blank slate every single time. It's not like me and another employee could have the exact same disability, the exact same set of circumstances, and the same court could rule against me but for him. Not really how it works. But it is an individual case-by-case basis, and the court must take into account prior decisions that are relevant. That's something I hope you've seen illustrated, a common thread throughout our semester. It's how all this gets applied. All right, so that's the ADA, Americans with Disabilities Act. Let's go into then the ADA case, Clark versus Champion. All right. Who can tell me who Charles Clark was? Who's Mr. Clark? Go ahead, Kenneth. Yep. He worked for Champion. And the nature of his job was training, hiring, that kind of thing. Security guards, I believe. And you mentioned he has a disability. What was his disability? Type 2 diabetes. All right. So back up for a second to the definition under the ADA. There was no argument in this case about whether or not diabetes is a disability. All right. Champion wasn't arguing that, but I want you to see how it qualifies. Is it I want to be consistent with your definitions. All right, the disability would be, is diabetes a physical or mental impairment that substantially limits one or more major life activities? It's a physical impairment. It does impact your day-to-day ability to if untreated, right? Without insulin, it would absolutely affect a diabetic's ability to do major life activities, for sure. All right, so he's qualified as a disability under the diabetes. So if we're looking at whether or not he could file a claim under the ADA, he has a disability, diabetes. Is he otherwise qualified for the job in question? Can he do the job? He can do the job. There was no argument about that. The argument in the case is whether or not he was fired solely because of his disability. That's the rub in this case. So Mr. Elrod is exactly right. Mr. Clark was in charge of hiring and firing. It was a personnel type job, an HR type job for Champion. And he did request along the way some accommodations for his diabetes. What were those? Who can tell me what one of those was? Yes, ma'am. Okay, he wanted a refrigerator for his office to store his insulin. What do you think on that, Melanie? Is that a reasonable accommodation? Yeah. Could he still do the job without it? Well, I mean, without the refrigerator in the room, in his office. I mean, he could. Yeah, he could pack a cooler. There are other ways. Like, that's not the only way that he could do it. But that's a reasonable accommodation, and Clark let him do that. There was another one that he asked for that they granted. What was that? Yep, he wanted to be able to leave to go to doctor's appointments. That's probably pretty common to all employees. Maybe not just somebody with diabetes, but Champion said that was fine too. All right, there were some things he asked for in terms of accommodations that they said no to. What did they shoot down? Louder, Elrod? Yeah, he wanted to leave his shirt untucked. And why did Champion deny that accommodation? All right, they said that the documentation that he provided didn't have anything to do with diabetes. It had to do with his shoulder surgery, right? And there just was no proof that Champion felt like there was that he could not tie his shoulder surgery to his inability to tuck in his shirt. That his documentation wasn't good enough. It did seem like Charles Clark gave them a bunch of reasons, and then they came back and pushed back a little bit, and he'd go back to his doctor and get a little more clarification or get a note that helped him out a little bit more. What was another thing that they denied? All right, Delaney, right? He wanted to grow a small beard, and initially they told him what? But no, but then they ended up giving in on that, right? Even though Champion made it pretty clear, we don't really think this is linked to your disability, but okay, we're gonna let you do that. Champion did draw the line, a hard line, at what? What was it that was the last straw for Mr. Clark's employment? He was sleeping. All right. So let's put that in the context of an Americans with Disabilities Act claim. What accommodation is he essentially asking for? To sleep on the job, right? That's the accommodation he's asking for. Can he perform the functions of the job even with that accommodation? Can he do it while he's asleep? No. So that's where Champion drew the line. All right. Clark, as many people do, and he had a lot of different things going on, right? So from his perspective, he felt like they were out to get him. They've been messing with me this whole time. They've been giving me a hard time about all these things that I need to do, like not tucking in my shirt. I think I was in a diabetic coma, or I had a crash out or whatever. And I ended up at the hospital. And what did they do? Call me at the hospital to fire me. Right? So from his point of view, they have not treated him fairly. So let's break down how that looks in court. His first claim, I think that the opinion takes you through, is that he believed he was being harassed on the basis of his disability. All right, I haven't mentioned that yet today, but harassment we talked about on Tuesday in this sexual harassment context can happen on the basis of religion, race, and disability. If somebody gives somebody a hard time because of their disability, makes fun of them because of their disability, creates a hostile work environment such that they're harassing them about it, that'd be a violation of the ADA as well. So, in support of his harassment argument, we're just on the harassment piece right now. What was his evidence? Yeah, the text message. That's right, Mr. Elrod. What did the text message say? Or it was the correspondence back and forth about the shaving and the shirt tucking in. Am I right about that? Y'all agree with me or not? Were you thinking of something else? You're thinking about the email that said, perfect, let him go, which we'll get to that in a minute. So the court said, these emails, the correspondence doesn't ever mention your disability. It's just a legitimate back and forth between an employee and an employer about what you need and what the reason for it is. Okay, in other words, it's not harassment for Champion to just have said, okay, we read this doctor's note and we don't see how that ties into your disability. We need some more information. Pretty harmless. Now, assume for a second that Clark had been there for 5 years, 6, 7, 8 years, and every single time he made a request or gave a doctor's note, they denied it, asked him to go back and get some more, pretended like they didn't remember what the doctor said the last time. I mean, I could see where that might be harassment. But in this case, the court says all we see in your messages, again, they're going to look at the evidence before them. It's not necessarily just what you thought, Mr. Clark, or how you felt. Show us the evidence that you say proves that they were discriminating or they were harassing you. And a disagreement between employee and employer about policy is not necessarily harassment. All right, so then we get to his claim about whether or not, well, the court starts looking at whether or not his claim is based on direct evidence. Think like smoking gun, like obvious on its face. If we have direct evidence, we don't have to do that burden shifting procedure I told you about on Tuesday. All right, if I have an email or a statement or proof that they fired me because of my diabetes, and the evidence shows it itself, that's direct evidence. I'm good to go. But he didn't have that. Well, right, he didn't have that, and the court said, let me take you through, Mr. Clark, what you think is direct evidence, and let me show you what we have found in other cases to be direct evidence, and then we're going to compare that against yours. His evidence, Mr. Elrod pointed out a second ago, what Charles Clark thought was direct evidence of discrimination was the supervisor's email that said, perfect, let him go. That was in response to the picture of him sleeping. The court says we had a case that was titled Portis, and the direct evidence in the Portis case was evidence of multiple occasions where the supervisor told the employee that she, as a female, wouldn't be worth as much as the men would be to the bank, and she would be paid less because she was a woman. Hey, we don't have to make any inferences about that. That's not really subject to interpretation. That's direct evidence of discrimination. The court talks through the ETN case. Involved a casino and an African-American woman. She alleged she was not promoted to a managerial position based on her race, and her direct evidence was that her manager told her he did not allow dark-skinned black persons to handle money at the casino, and that the employee was too black to do various tasks. That, the court says, is direct evidence. Right? We're not having to connect A and B on that. We can read it on its face. That's obviously direct evidence of discrimination. The Rodriguez case. That was a case where the employer admitted that the employee did not get the job because of her uncontrolled diabetes. All right, so those are examples where the court in the past, in other cases, has found direct evidence. So then they take those statements that I just read you and they compare that to Charles Clark's direct evidence, perfect, let him go. What's the difference between perfect, let him go, and you're not going to be paid the same because you're not a man? What is the difference in those? Say that louder, Caleb. Yeah, one of them you got to interpret. One of them subject to different meanings, or could be. You could argue it either way, right? You're going to be paid less because you're female. That's not really subject to any two ways of looking at it.
Does it have to be recorded or in text messages?
It doesn't have to be recorded or in text messages, but you would need witnesses. So this case, remember, this is an appeals court. The trial court found for the employer. So the trial court would have already heard all the evidence. And the best thing that Clark could point to from his trial was this perfect let him go email. All right, knowing what you know now about how the court looks at a statement of direct evidence versus Clark's of perfect let him go, if you could rewrite, well, let me back up. The email to the Charles Clark supervisor said, the subject line was Charles Clark sleeping at work, and then a picture of him sleeping. All right, the court, and the response, perfect, let him go. The court says that does not tie in his disability or diabetes. How could you rewrite the subject line of that email better for Clark? How could you rewrite the subject line of that email and make it direct evidence of discrimination?
We're going to let this diabetic go.
There you go. Time to let the diabetic go. How about Charles Clark in a diabetic coma? Perfect, let him go. All right? That's a lot stronger than perfect, let him go just based on him sleeping. All right, so the court shoots down his direct evidence claim, and it says, you're going to have to proceed then, Mr. Clark, under the burden shifting analysis. You're going to have to show us that you were qualified for the job, that you suffered an adverse employment action. We're going to ask Champion what the reason was. They're going to give it to us, and if it's not discriminatory, then you're going to have to prove that that is pretext or cover for discrimination. All right, so Clark says, I have diabetes, and I got fired. Court says, okay. Champion, what is your legitimate, non-discriminatory reason that you fired him? Champion says what? Sleeping on the job, right? We have a policy manual that sleeping on the job is a terminable offense. We do this to everybody. In fact, what had Charles Clark done throughout his career? What had he participated in? He had been a part of firing people for sleeping on the job, right? Couldn't say he didn't know it was against the rules. All right, so then the burden shifts back to Clark to show that Champion's reason is just cover for discrimination. Yeah, they said I was sleeping on the job, but it was really all these other things. And the court ends up looking at all his other things and doesn't find that that constitutes or rises to the level of discrimination. Mainly because his argument is essentially, and I think y'all already said this today, his argument is essentially, I need an accommodation in the form of being able to sleep at my desk. And we know from our discussion on accommodations, you still have to be able to do the job even with the accommodation. Could Charles Clark have performed the functions of his job with the accommodation of sleeping? No. You cannot sleep and do your work at the same time. Those are incompatible. All right, so that's how Charles Clark's last good argument failed. He didn't show that any actions taken against him were based on the disability. Now, as a practical matter, put yourself in the position of the supervisor at Champion. You've had enough of Charles Clark, okay? We all know employees like Charles Clark. Always needing something, always making excuses. You guys got coworkers like that? Anybody think of a coworker like that? No names. We know that is. All right? You're the supervisor. You want to get rid of Charles Clark, but you got to do it the right way. Because I want you to think about decisions that you make as a manager, a hiring manager, or supervisor, and how that's going to look through the lens of litigation. Okay, I really want to get rid of Charles Clark. How can I do it in a way that I've documented it such that if we go to court, I can show that it was because he was sleeping on the job, not just because I said it was or said everybody was tired of it. Do his performance reviews have this in there? Has he been reprimanded for it? Have we talked to him about it? Did we give him a chance to give us a reason? In this case, you really can't look at anything that that the supervisor did and not say that they pretty much gave Charles Clark all the chances he could. In fact, they could have fired him, or they could have tried to fire him earlier based on an anonymous picture of him sleeping. Remember that? And the supervisor was like, our policy kind of requires, the way we've done it in the past with other employees is we like to have 2 witnesses. So if they'd have fired him then based on an anonymous picture, Charles Clark's case would have been a lot stronger in court, because he could have said, they treated me different. All these other people that they fired for sleeping, they had witnesses. They didn't have any witnesses on me. So I say that to highlight the importance of consistent application of policy and judgment and decision making by managers, supervisors. You don't have to go out of your way or bend over backwards to accommodate everything for an employee, but you need to do for one what you've done for the other, so that it doesn't look like down the road that you treated that person differently. Consistency, documentation, all that is very, very important in employment law, because hopefully by now you've learned to think about these things through the lens of how the court would look at things in hindsight. All right, maybe Charles Clark slept every single day, but I don't have any pictures of it. Am I justified in firing him for sleeping every day? Yes. Is that going to be harder for me to prove in a lawsuit? Yes. Right? I'm not saying he deserves to keep his job, but you've got to think as a supervisor or a manager in terms of how this might look in a lawsuit. This is why people hate lawyers. You're telling me that I can't fire somebody for sleeping every day? What is this world coming to? I'm not telling you that. I'm just saying that you need to have all your evidence lined up. All right, that is the case of Clark. Let's talk. Anybody have any questions about that case? All right. Does anybody have any experience in their jobs where somebody that works there has an accommodation for a disability that you know of? Caleb. Yourself, okay. Do you want to tell us about it? All right, type 1 diabetic, and you requested an accommodation?
I was working as a bagger for commissary back in Texas.
Okay.
And the only accommodation I ever asked for was being able to keep my bag in the break room. And basically the policy was no bags at all.
The policy was no bags in the break room?
No bags at all.
And you wanted to keep your insulin in a bag in the break room?
Basically, I asked if I could keep this with me.
Okay.
I needed like a test or give myself insulin. And basically I asked that. First week or so, they said, okay, yeah, that's fine. But then after that second week, the head bagger started making small comments of, oh, why I need your back. Yeah, it was not a fun time. Eventually, after like a week or so, after that, I was just like, no, I'm done. I'm not gonna deal with her anymore. So I left. But as I was leaving, I filed an ICE complaint. And I don't know if anyone really knows what that is, but in the military, an ICE complaint is you can file it for anything, including discrimination, harassment, sexual abuse, and that is
It's employment related complaint
well, it's
or
anything.
just base wide. Any,
Base-wide.
okay.
And it's basically for anything that you're like, this happened, I want someone to look into it.
Okay.
It was looked into, and I found out later that she had been let go for about a week or so while it was going on, but then they just brought her back.
Oh. All right. So that you were discriminated against based on your disability, based on what we know about the ADA. I'm sorry to hear that, and I appreciate you sharing that story. I was not expecting to get a spot on example of it, right? But you ended up leaving that job on your own. Okay, they didn't fire you. What did we learn on Tuesday that Caleb could still have argued even though he quit? Yeah, that they forced him to, and we call that, or that he had no choice based on their treatment of him. We call that constructive discharge. Yeah, he quit, but he was really fired because he had no choice but to quit. Constructive discharge. Good. Any other questions on Clark? All right, let's go to the Bostock case then for a second. Bostock versus Clayton County. This involves what federal law? What law are we talking about in Bostock? Title 7, Civil Rights Act of 1964, right? And the text of that statute says it's unlawful to discriminate in the workplace on the basis of race, color, national origin, sex, and religion. All right. Which part of that statutory wording is at issue in this case? What word is at issue in that case? In this case, sex, right? All right. So Title VII prevents discrimination based on all those things. This particular case involves the word sex, and the way it's set up is the question the court has to answer is: does that one word in the statute, does that cover discrimination based on sexual orientation or transgender? Because it doesn't say that in the statute, it just says sex. So the question before the court is, does that one word also include or mean sexual orientation? We understand, we've always interpreted this to mean male or female. Those are the cases that have been brought under Title VII for sex discrimination. They've not been brought under orientation. So we've interpreted this in the past as meaning you can't fire somebody because they're female, you can't fire somebody because they're male. To put it another way, can you fire somebody for being gay? That's the question that the court has here. So what kind of job did Mr. Bostock have? Yep, Child Welfare Services. In Georgia, that would be like DFACS, we would call them. That is a state job, so he's a state employee, and he believed that he was fired because he was gay. He sued Clayton County. At the lower trial court level, he lost because up until his case, the courts had always found that language in the statute, no discrimination based on sex, did not cover orientation. It only covered male or female. But he's making the argument in this case that ought to change. So the court is having to interpret the words of a statute, which they often do. if you're the court and you're having to try to figure out if this word sex covers orientation, what are some sources that you might go and look to? What are some considerations they would take in? When was this law passed? What year? 1964. So that's a starting point. The court would go back and look at, well, what did Congress mean in 1964? What was the ordinary interpretation of that word in 1964? Right? The law didn't get written last year, it got written in the 60s. So we need to interpret it based on what we thought they meant. So Clayton County's argument is based very much on the fact that we go in the time machine back to 1964. Would the general public have understood that the word sex meant sexual orientation or transgender? That was not part of the cultural awareness, lexicon, vocabulary. It wasn't part of the accepted, it wasn't an accepted part of society in the way that that it has evolved to now. It was viewed differently in 1964 than it's viewed in 2026. I think we could probably all agree on that. All right. So that's Clayton County's argument. The flip side of that argument, not the flip side, but an extension of that argument is, if we're not sure what Congress meant when they passed that law in 1964, who's the best person to tell us what they meant? Congress. And they could fix this themselves by what? A change in the statute, amending the statute. There's nothing stopping Congress from passing a law that says, from amending this law that says can't discriminate based on sex, and we include that, we find that that includes sexual orientation or transgender status. They could, if Congress passed that law tomorrow, that'd be the law. So part of Clayton County's argument is, courts, your job is to interpret and apply the law, not to change it. And what you're doing is basically changing the law, and so you're doing Congress's job. You're overstepping your bounds. You're writing laws. And the Constitution leaves that responsibility solely to Congress. So that's Clayton County's argument. Bostock's argument, and the argument that the majority of the court adopted, because he won the case, what was the rationale? If you had to explain to me in plain terms, how does the court believe that sex includes orientation and transgender? What would you tell me? Or could you? How'd you break it down? So Justice Gorsuch, who wrote the majority opinion, this is how he explained it. He said, y'all are, the dissenting justices, the people who are arguing for the county, y'all are trying to act like this word sex doesn't automatically include sexual orientation. What are y'all talking about? He said, I could have two employees, one male, one female. They're both attracted to men. If I fire the male for that, but I don't fire the female for that, I have made my decision based on male versus female. I've based that decision on their sex. And so I don't know how, this is Justice Gorsuch, I don't know how that could be any plainer. If I treat one person differently who's a male than I do because they're female, the only difference is their gender, then I have discriminated them on the basis of sex. And as Justice Gorsuch says, there's just no other plain way to put it. The dissenting justice's main argument was, You're making law. You're rewriting the law. It's not your job. We have Congress to do that. We have elected representatives and senators, and if they feel like the law needs to change to reflect the changing of the times, that's up to them. Did anybody catch maybe the best argument for the Clayton County side about Congress changing the law? Had Congress considered changing Title VII to include orientation? Who says yes? Yes, Melanie. There was actually, they said there have been bills proposed in Congress to amend Title VII to include orientation and transgender. And guess what Congress did? They didn't pass it. So what better evidence do we have that Congress didn't intend for that to include orientation than that? If I'm the lawyer on the other side, I would say, you're exactly right. They didn't pass the law to amend it because they believed it already included it. There was no need to amend it. All right, you see how this goes back and forth. Justice Kavanaugh wrote an interesting dissenting opinion where he said, I think that Title VII should prevent discrimination based on orientation. Absolutely it should. I just don't think that what they wrote does. So I agree with the cause. I agree with the idea. I just can't agree that that's what this law says. These are 9 justices of some of the best legal minds in the country, and they disagree. So if anything, I hope this illustrates to you that there's not much in the law that is truly, truly black and white that we can all agree on. We've got this one 3-letter word from a law in 1964, and 9 of the brightest legal minds in the nation can't agree on what that means. They're influenced, obviously, by their values, maybe their political leanings, maybe their religious beliefs. They're not supposed to be, but that's one way to explain how smart people can disagree so differently. All right, questions about the Bostock case? No questions? Questions about anything else? All right, that's all I have to say. So I'll see y'all Tuesday for exam review. Oh, sorry, we had a question. He did not win the appeal. He did not win until he got to the Supreme Court. Yep. All the courts below the opinion you read found for Clayton County. Good question. Or else Clayton County would have been the one appealing. Right. Okay, good question. All right. See everybody next week.